having today our first webinar presented by the Marketing Committee. We hope to make these a quarterly appearance, and our kickoff is going to be by Vicki Vinker, who's going to be talking about patent mediation and innovative paths to patent peace. Vicki, as an aside, I should tell you, I understand there's a new White House slot for the peaceful resolution of disputes, and they're looking for candidates, so you might check that out. Let me introduce Vicki. She is a very highly experienced mediator, particularly in regards to patent and other IP disputes. She's on the mediation roster for the International Trade Commission and both the mediation and neutral evaluation panels of the U.S. District Court in the Northern District of California. Vicki's got 25 years of patent trial and appellate litigation experience as a partner at Sherman & Sterling, where she founded its Silicon Valley IP group. Previous to that, she was a partner at Fish & Neve in Palo Alto after beginning her career in New York. She's recently founded Vinker Law Offices, which of course represents parties to IP disputes, and she does a great deal of mediation in that context. Interesting fact, which is on her bio, and I always found fun to talk to her about, was that she was general counsel to the Women's Professional Soccer League for several years from 2008 and 2010. So Vicki's got a really sterling resume. It's kind of intimidating to read it, super clear and all these other things. You all can see it in more detail on the website. But let's just launch right into this now, Vicki, and you can take it away.
Okay, great.
Oh, well, before you start, I'm sorry. One more administrative, my mistake. Those of you who wish to post questions, I'll try to moderate the Q&A as we go, and we'll have a period at the end. If you click the little chat box that should be on your computer, anytime during the presentation, you can type in questions. I'll keep track of those, and then we'll have an opportunity to put some of those to Vicki, either at a break in the middle or at the end. Okay, sorry, Vicki, it's all yours.
No problem. Well, thank you, Chris, very much for moderating us today and for that generous introduction. I'm grateful. And thank you to SVAMC for hosting this today. I endorse these webinar series as times we can share with each other our practice expertise and promote the alternative dispute resolution practice in the technology industry generally. So thank you. And thanks to all of you for joining today. I appreciate it. We have an interesting group literally from around the world, so thank you. So yes, as Chris mentioned, I've spent now 30 years in IP law, 25 years litigating patent cases in big law, first at Fish & Neve, actually, which is now part of Ropes & Gray, and then at Sherman & Sterling. I know these days I'm supposed to say that I'm an intellectual property lawyer. I guess somehow we got smarter than when we used to be patent lawyers. But I really want to focus today on patent cases, on patent disputes. So this is an experienced group on the phone, for which I'm grateful. So let me just make a couple of notes. I'm going to approach today's webinar as really a tips and techniques session, and not so much a nuts and bolts session because of the experience level of those who are dialed in today. But just to set some groundwork and background, there's two key aspects of patent disputes that I think make resolving them a little different. One, obviously, they must involve technology. You know, I remember back when I sat for the patent bar exam 30 years ago, it was a big deal that biology had been added as one of the degrees you could have that would allow you to sit for the patent bar. So, the inventions claimed in these patents, necessarily involve technology, and so there's a real aspect to communicating about that has to be honored, really, in trying to resolve these disputes. Anyone can litigate a patent case. You don't need the degree for that. But in terms of really understanding and keeping it from getting in the way, frankly, of people figuring out if there are commonalities that allow them to resolve their dispute, it really needs to be recognized and respected. Second, patents are a government grant. Other forms of IP, trademarks, copyright, trade secrets, there's sort of inherent rights that the user generates, but patents, you don't have any rights until the government says so. So that means a lot of the issues involve what a government employee did or may do. So what they did in granting the patent or what they might do in reconsidering the patent. So it's an interesting aspect of where the merits will lead that you have to analyze that aspect. So it's complex. These disputes are dealing with those two types of central issues for a fact finder, be it a judge, a jury, or an arbitrator. They're tricky issues. So perhaps that's why I now call myself a recovering litigator after 25 years. So now, for the last dozen years or so, I have, as Chris mentioned, served as a mediator at the federal courts and the RTC, but have also adopted and adapted patent mediation principles to my representation of clients as an advocate. I just do it prior to or in parallel to litigation, and I'll come to that at the end of my presentation. So, why mediate a patent case? Well, I think, what way I think about it is, why mediate a patent case when instead you could just let 12 people off the streets of San Jose decide, or Plano, Texas, or Wilmington, Delaware. And what I tell clients and litigants is the reason you should mediate is that no one else, no judge, jury, or mediator will ever know your case as well as you do. No judge, jury, or mediator will ever know your business situation that forms the backdrop for your case as well as you do. And no one will ever spend as much time thinking about your case as you do. And so as a result, necessarily, no judge, jury, or mediator is in as good a situation as you to figure out how to resolve your case. So in sum, if you can settle it yourself, you'll introduce some modicum of certainty and reduce the risk in what is otherwise a very high stakes and sometimes high risk litigation situation. So I want to talk a little more about how to make the mediation experience really useful, really a practical tool. So when people come to me through private mediation, they're already there in terms of believing that they can make some progress by talking to each other, and that perhaps that's a good alternative to explore. But other times when I get cases perhaps through the ITC or the federal court, people are doing it because they're supposed to, frankly. And I always start that conversation by saying, I'm not interested in conducting a check-the-box mediation. I am interested in discerning how we can tailor the process to meet the needs of the parties. And almost always, we can find a way to make it useful. Now, sometimes it's just not right. And if so, I encourage the parties to wait. And I'm happy to tell the court that I think we should wait. So it's not a mediation all the time at all costs, but often if you skillfully adapt the process, you can make some progress. So obviously when people walk into a settlement meeting, to a mediation, settlement is their primary goal. But I believe firmly that a mediation session can be a success without necessarily a settlement if the second goal is achieved. And my second goal for absolutely every session is that the parties will walk away knowing why, having a clearer picture of why they're still fighting. And sometimes that may sound simple, but sometimes people walk in and they don't really even understand what they're disagreeing about. The issues don't meet, the papers have been filed, but if you can help people simply crystallize, that about which they disagree, that can be tremendous service to the parties. So in terms of putting the mediation session together and what parties can get from it, there's several unique opportunities that come from mediation. So people often ask me, do you start by putting the parties in the same room? It was interesting, just a couple of weeks ago, I was at dinner with a couple, friends of ours, and the husband is a CEO. He's been a sort of a serial CEO of a number of companies, and he asked me, he said, when you do these mediations, do I need to come and start off by sitting in the room with the other side? And there's not a uniformity of opinion about best practices on this point, so I'm just going to give you my view. My view is that absent some extraordinary circumstance, yes, I like to start with people in the same room. The primary reason is, if you don't succeed in settling a case, you are going to be in the same room with that opposing party, and it will be a room far less pleasant than the mediation room. It will be a federal court, and there will be much stricter rules, and there will be much higher stakes, and there will be a much less well, I don't want to say friendly, but amenable person at the end of the table. Instead of me, there will be a federal judge who will tell you what the result is. So I think it's a unique opportunity, actually, for the litigants to assess the other side and assess their case. So on that point, it's an opportunity to hear the opposing litigator describe the case. Up to that point, you've heard your own counsel honestly and candidly tell you what the merits are, but it's necessarily filtered through wanting to win. It's necessarily filtered through knowing you and wanting to advocate for you. So it's kind of an eye-opener sometimes for people to hear the other side express their view of the case. Now, I encourage people not to, infuse too much rhetoric or vitriol. It should be a calmer statement of the case. But to hear it framed by another is a really unique opportunity in a case. So I encourage people to take advantage of that. And frankly, it does balance your own litigator's optimism. But the other thing is, you might find during that session that the opponent's goals in bringing the case or the defendant's goals in arguing certain defenses are not what you thought. And you might find opportunities for business settlements and agreements that were not apparent to you, because people mad enough to make a federal case over something are usually not the best communicators. And so communications get strained. People, intuit and interpret acts to be certain messages that may or may not be there. And this is a chance through a skillful mediator to find out what's really going on. What is it they really need out of that lawsuit to put it behind them? And of course, it's an opportunity to exchange facts outside of discovery. So we all know about, massive U.S. discovery practices, the time and expense and hassle that goes into those. But in a mediation session, you can identify certain factual information that might be key to resolving the dispute if the other side just knew it. And you can arrange comfortable ways to exchange that. So it might be a subset of what a discovery request would seek, And it might only go to the outside counsel, or it might only go to one person inside on the company on the other side. But you have an opportunity to learn some facts you're curious about and tell some facts you want to make sure they know that would otherwise get in the way or would be months down the road in the discovery process. So it's really a unique tool for understanding your own case. And as I mentioned before, it can help you clarify just exactly what you're fighting about. So the other aspect of the patent case that I mentioned is the technology itself. And so why mediate? Because the parties in the council will understand that technology far better than a fact finder likely ever will. Now, you might get that software engineer or electrical engineer on a jury, but you might not. Or you might get that person and they sort of de facto become the leader, and maybe they're not quite as expert as they'd like to think. But in the mediation room, you have the people who have lived the technology. You have a counsel who have invested a tremendous amount of time in understanding that technology. And they are in a unique position to evaluate the merits. If they instead go outside the mediation process, they're going to have to get into detailed, complex explanations that judges, there are many extraordinary federal judges who spend a lot of time and do a phenomenal job of understanding the technology. But, jurors are hit and miss. Some judges aren't as interested, or they're just too busy. And it's hard. It's hard stuff. Jurors might try at first and get tired. Or they think they've got it, and then they listen to the experts on the two sides and throw up their hands. I don't know how many of you have had the opportunity to debrief jurors either after a mock trial or after a real trial and ask them some questions about the technology and some of the technological issues. But it can be quite illuminating. I've done so and gained both a high regard for jurors and the tremendous seriousness with which they take their charge, but also a little bit of skepticism, because sometimes when they tell me about factual issues, I think, nope, that's not quite it. So you just take that factor away when you're in the mediation session. But my favorite reason to mediate, to get the result you want. You simply can get a far greater range of outcomes through mediation, because you can do things that a federal court or the International Trade Commission or the Federal Circuit or a foreign court on patents simply can't give you. They are restricted in the range of remedies they can offer. But if you are instead negotiating a solution, all kinds of business opportunities open up once you communicate, once you find out the real reasons the other side is at the table, and once you find out what their real needs and interests are in order to put it behind them. So you might do a cross-license. You might do a distribution agreement. Maybe you'll redesign the product in a way that would be different than what an injunction would require, but is good enough for the other side. You can sell your company to them. You can sell the patent. They can sell the patent to you. And my favorite story, the last one there, you even supply the patentee with the infringing product. So I was mediating a patent case in a federal court, and the patentee was a sole inventor. He is, up against a very sophisticated, very large technology company. So at first it was, this is a shakedown. But we got into the mediation process. We met once and began to realize there's a little something there. We met a second time, had a long day's negotiation. And it turns out this at the end, we were getting kind of close. I couldn't quite get it done. And I went into the room with the patent owner. And this is a guy with high school education, but he just figured out some interesting technological inventions. And he looks at me and he says, you know, I'm just a guy. I can't make the product that I invented. I can't manufacture it. But they do a really good job. They really embodied my invention quite well, and I really like their product. I wish I could have a lifetime supply. I stopped him and I said, "Are you serious about that?" He goes, "Yeah." Would you like to consider that as part of? Would you take that as part of an offer? And he said, "Yeah." So I go into the other room. Long story short, we ended up with a deal where there was, some money changed hands, but the guy got a lifetime supply of the product, the allegedly infringing product that embodied his invention. So a federal court can't do that. We would never have had a conversation where you would realize that was even something that he would want, but for the mediation process. So that creative aspect, you never know where you can go to resolve something, is one of the reasons I'm a big fan of the mediation process. So, and obviously you are in control of the result. If that's not going to work for you, then fine, you can move on to a different solution, and you can always go back to the court, of course. So just a few things about setting up the process. My pro tip. First of all, for timing, no one size fits all. There's a lot of folks who believe you really need the Markman hearing to construe the claims, to figure out, the legal issues, and that will be highly dispositive of, infringement and validity. If we just know the facts and someone tells us the scope of the claims, we're good. My view is, yes, sometimes, but the federal courts here in our district, in the Northern District of California, start with a pretty early mediation process. And I agree that it should be explored early. Sometimes you can save yourself a lot of time. Sometimes you don't need a claim construction. Sometimes the claim construction is not nearly as definitive as one would hope. But if it is not ripe early, if there are serious needs to develop the facts, then I don't think it's worth forcing. So timing is a matter of circumstance. Obviously, if you do it early, perhaps the parties aren't as polarized. It may not be as emotional. They won't have read all those, snippy motions that sometimes get filed. And they will not have sunk all the costs into the litigation where they feel like they need to then get a certain result to justify the expense. But if you do it later, as I mentioned, you're more informed about the facts from the discovery. And you may have, they may have dropped a patent from the case. There may be certain products that are no longer accused. So the issues may have narrowed on their own. But the big thing about mediation timing is that you don't look at setting just one time in the process. In the litigation, mediation is a process. It starts before the first session and can continue on for however long it makes sense until the dispute is resolved. The first case I did more than a decade ago, we met a first time in San Francisco, as it was, got very close to settlement. It did not settle. 3 months later, we met in Washington, D.C., got very close to settlement. It did not settle. 3 months later, we met in Boston, got very close to settlement, did not settle. Almost a year to the date from the beginning, we met again in San Francisco, and at that time, this is a very complex case. There were patents going both ways. There's enormous markets at stake. There were actually 3 different forums involved. But that time, we finally settled. And the best thing in my view about it was that after we settled, we all went out for a drink together. And that just shows that what we had done was develop the relationship that allowed the communication and the exchange of facts and positions so that we could navigate the complexities and figure out where there was an overlapping solution that was acceptable to both sides. So it's a process, not one and done. Second thing, The mediator is not a judge. I tell people, I don't decide anything, period. Former judges are very popular mediators, and many retired judges are excellent mediators, so I'm not saying they're not. But I think it's funny and a little ironic that that is sometimes viewed as one of the best determinants of who would be a good mediator. The reason I think it's ironic is judges make their living by telling you what to do, by ordering you to do things, by deciding things for parties who can't resolve it on their own. Whereas a mediator needs to talk to the parties so that they can decide it themselves. It's a different skill set, and some possess both, but not, it's a different skill set is my only point. And in my view, the real reason people often hire judges to mediate, it's one I didn't want to write on the slide, but honestly, they think the judge is going to come in and tell the other side they're wrong. I mean, we often like judges because of their experience at judging, at evaluating a case, at figuring out what a jury might be likely to do with a set of facts, or a given judge that is presiding. And that's very valuable, but that's a very evaluative model for mediation, which many litigants arrive at the mediation table with. But most skilled mediators often decline to evaluate a case, or decline until late in the day and to give a third view, but not to base it on that. And what's funny is often both sides want the judge because they're sure the judge is going to tell the other party that they're wrong. So just bear in mind, mediator is not a judge. Next, pre-session setup is key. This is one where I heartily embrace the process set forth by the Northern District of California. The pre-mediation telephone conference is just a marvelous opportunity to get to know the parties, to have the outside counsel speak to each other. It will already focus the conversation, and they will help you identify who really needs to be in the room. I also believe you should require and review mediation statements in advance, because not just to educate the mediator, but because in creating those, in crafting those, the parties go through the kind of analysis of both their case and their desired outcome that is critical to having a successful session. And the key is for them to then share that with the other side. Now, obviously, there's confidential information that they don't want to share. And in that case, I do encourage them to tell me so that I can have in the back of my mind what may be really going on. Is a sale pending, or is it or coming up, or being considered? Is getting into a new market or out of an old one something that's going on in the background? Clearly, you can't share that kind of strategic considerations, but knowing that will keep me from pursuing what could be a dead-end settlement option. So I always encourage folks to tell me as much as they're comfortable with about background of the dispute. And then, of course, it's a great chance to get a little preview on the technology at issue. Patent litigators are expert at communicating tough technology, and they will do that in their brief, their mediation brief. But sometimes getting a little oral preview will key you in on the issue you really need to learn, and or tell you if you need them to educate you a little more. So it's a unique opportunity to do that. So setting everything up, evaluating the timing, as I mentioned before, getting the right people in the room, that will go a long way to determining your success. All right, so tailoring mediation to the peculiarities of patent cases. There's just a couple of situations I want to mention briefly that I think are interesting and come up in these cases from time to time. The first is a founder CEO. Most of you have probably encountered this when you still have a company of a size where the man or woman who figured out the cool technology upon which the company is based is running it. That makes the dispute very personal. And as a mediator, you should be aware of that and consider how to still keep the room in a place where that founder will keep an open mind to settlement. And so things like patent invalidity to a founder can be highly almost offensive, and it will at least provoke a strong response. Now, we all know as attorneys that what was invented and what ultimately gets claimed in a patent and what gets issued by a patent office and how it gets defined in litigation is not the whole story on an invention, but for the inventor, it can feel like it. So being aware of that is something important. On the flip side, that just because the founder, CEO, finds the case very personal, and they may get a little emotional in communicating about the import of their patent, it doesn't necessarily mean they're wrong. So be careful of going too far the other way and discounting that position. So just things to bear in mind, because it's something that doesn't often come up in other types of cases. And then just a moment, there's been a lot written and a lot of discussion about mediating cases where you have someone trying to monetize a patent. I put the pejorative troll there just for shorthand, not meaning to disparage, but this is tough because instead of having two operating companies competing for a market, you have one who's not. That means they're not susceptible to patent counterclaims. They don't, a lot of those creative results I had mentioned earlier aren't relevant to them. It's much more focused on money. But bear in mind that if they lose a patent case, yeah, they may have more patents, but it calls into question the value of their portfolio. And if they don't have more patents, then they're in real trouble. So, looking at just noting that distinction from other cases will help you navigate that mediation conversation more skillfully. And one of the ways, one of the major considerations, in my view, in the troll cases, is also a consideration in frankly almost every case. And it has to do, it's one of the most significant barriers to settlement in my experience, and that is the people who are not in the room. And I say this to folks during my mediations, that you get very focused on the party in the other room, but oftentimes it's third parties that evoke the most concern during a settlement conversation. What I mean by that is, if you are the patent owner and this person's, for whatever litigation advances maybe the defendant has made, they want a really good deal, that's hard for the patentee because it could set a low value on the patent when they assert it against others. So they're worried about the impact on the people who are not parties to the instant case. Similarly, the accused infringer doesn't want, even if they have the money and they think getting out of it would be worth it, they don't want to appear as an easy target for the next guy with a patent or the next monetization campaign. So patent owners have to deal with the fact that the person they're talking to is afraid of that. And people always say, I'm going to stand up to this patent owner, and because then the next guy won't come after me. Well, in my experience, that's not necessarily true, but people believe it's true. So you really need to work with the parties to recognize those concerns and craft ways to deal with those. And then another often barrier is that a party may realize that their case just got a lot weaker on a given point, but they don't know how to say so. They don't know how to say so because they back themselves into a corner, or they might lose a lot of faith, feel like they'll lose credibility with their client. And so those are the times that perhaps, unlike in litigation, you want to try to help that person find a way out so that they can act based on this new awareness and not necessarily acknowledge it. So, you know, there are examples of this. So, for example, if you come up with a great piece of prior art and the patentee kind of realizes that there's a serious validity issue, but that's a rough thing to admit. There's all kinds of ramifications of that. You know, perhaps if they start talking about, oh gosh, the sales during the term of that patent weren't so high, or gee, my expert overlooked something in an infringement analysis, let them do it. You know, let them do it. Build them an off-ramp. Let them save face, because if that's what it takes to get them to resolution, it's worth it. So those are my thoughts on building a good mediation experience. I'd like to move on to other ways to use mediation skills in other settings. But first, I'll take a break and see if anybody has any questions for this portion.
Vicki, let me start for the group by asking this question. Now, when a case doesn't settle in your experience, how do you leave things with the parties at the end of the session?
So if a case doesn't settle, I try to recapitulate what movement I've seen during the day, what agreement there was, say, on the importance of an issue, the business landscape, certain factual information, and try to identify what issues are outstanding. And, you know, ask the parties, usually separately first, if they thought they made progress and what interest they might have in continuing the conversation. And almost uniformly, there is interest, because they can see that it's a unique opportunity and they've learned a lot about their own case that day. But then what I tell them when I bring them back together before we part is that it is my practice to check in with them a little way down the road. And that if I do so, do not assume it's because the other guy, you know, saw a weak point in their case and put me up to it. I mean, I just do that. So it may be because the other guy saw a weak point. And frankly, I encourage them, if they get to a point where there's you know, some turning point in the litigation, things have been added, subtracted, decisions made that they think create a new opportunity for exploring settlement, you know, whether maybe a case has stayed and it's going to an IPR, you know, there could be a variety of things. To feel free to reach out to me at any time and talk about whether or not that's a good opportunity, and that I will then speak to the other side without saying that I was sent. And I think being able to offer yourself as that tool, people are always curious what the other side is thinking. And the most fascinating thing to me about being a mediator after litigating for all these years, you know, I sat for so many years on one side of the table wondering what in the heck those people over there. Now I can walk into the other room and ask them. And that's facilitating that kind of understanding is something that I think is a real tool, you know, valuable tool to offer to litigants. And so I always make sure that before we part, I let them know that I'm available for that. And I'm often, very often, people take me up on it.
Great, that's helpful. Now, by the way, just a reminder to everybody, feel free to put any questions you may have in the chat box that should be showing on your computer. Vicki, you have a few more things. We have another probably 15 minutes. So why don't you go ahead and we'll have another break in a few minutes for any final Q&A.
Okay, great, will do, Chris. All right, so the other thing I wanted to talk about is alternative paths to patentees. And so what I mean by that is, you know, I'm obviously a big fan, big believer in mediation. But there are some other ways outside of litigation or arbitration that the parties can be in control of a process and participating in a process to help resolve their disputes. And so listed a few here, and I call it fitting the process to the problem. I want to share with you, I don't know, Les, I think you may be on the phone, but Les Schipelbein sent me a note when he saw I was doing this session just recently, noting a Wall Street Journal note from March 8th about Frank Sander, who was a pioneer in alternative dispute resolution and mediation. And he apparently called it fitting the forum to the fuss. So thank you, Les, for that, because I love that. I had process to problem, but forum to the fuss is the same kind of concept. And I think that's it. The key is to really be aware of the array of tools we have to deal with a given dispute. The first one I wanted to mention is that, you know, a court has to deal with issues that are in front of them, as does an arbitrator, what the parties bring to them in a given dispute. As a mediator, the very first mediation I did a dozen or so years ago, I was initially assigned to the patent suit from the Northern District of California. When we had our pre-mediation telephone conference, the parties noted that they had, while patents were going one way in Northern California, they had another suit with patents going the other way in Southern California. And they had a third suit in the International Trade Commission involving some of the same patents. And so they wanted to know if they could consolidate all three of those in one process. And so I said yes, because that's part of the beauty of mediation, is it can be very holistic. And the wonderful thing about that dispute was, I mean, it was incredibly complex. You know, early on in the first session, we realized that the parties didn't even agree on the order of magnitude of the sales involved. So our next session was all about, you know, damages, because of course the ITC case, which was the furthest along, doesn't have damages discovery. So we accelerated that, exchanged information, and dealt with it. But the ability to combine all of that into one discussion really was what it took to address the whole problem. And we ended up at the end of our time together settling not just those three cases, but all of the worldwide disputes between the parties. And so that's a wonderful flexibility. Most of you are familiar with early neutral evaluation. The federal court here does it. Many other jurisdictions do it. I would like to suggest that a correlate of that, private neutral evaluation, is something that I've seen used successfully. I've done it both as the neutral, and I've done it as an advocate where we've hired a neutral. And typically, private neutral evaluation is appropriate when there's a single issue that both sides know is key to resolving the dispute, and they just disagree about it. And they're looking for an informed opinion from a third party whom they both respect to give them a sample of how it might go if they were to litigate it. And, you know, I've done this where there's been briefing, like serious litigation briefing. And in one instance, when I hired a neutral, the neutral then asked us a new case came down, they asked us to brief that case, and we went through it just like an arbitration, except it was mini. It was just on that issue, and it was against the backdrop of a pending federal litigation. But once that opinion was rendered by the neutral, it led to richer conversation about the issues, and ultimately to a facilitated settlement. So bear in mind, you can do it. You don't need the full massage. You can craft it to fit your dispute. The other thing that is sometimes done, and I've been asked to do, and I've done a couple of times, is people ask you to be a neutral evaluator and then to be the mediator that facilitates that follow-up conversation. That's tricky. I've seen it succeed, but you have to be highly aware of a risk there, and here's what that is. So you go through the evaluation process, either on the whole case or a part of the case, whatever the parties feel is most useful. You can win them over by demonstrating your facility with the law and the technology and your understanding of the facts and your attention to their case. And so that's a wonderful thing to do before you mediate. However, what I always tell the parties right before I tell them my opinion is, you all may be happy with me right now, but as soon as I read this opinion, one of you is going to think I'm brilliant, and the other is going to think that I just missed it. Either I wasn't that smart, wasn't that informed, or I just didn't understand them. And that's very likely to then carry over and affect the way you interact with me as a mediator. You will no longer perceive me as neutral. I now have a point of view, and it's human nature to want to defend your point of view. So by telling them that, it does tend to diffuse it, and I have gone on to successfully mediate the case after that. And so it can be a useful tool, which is why I put it on this slide, but there is a certain risk. And I think if you deal with it head on, you can navigate it, but it is something that you need to be cognizant of in setting up a process like that. So next, this is what I do a lot of now, and I wanted to mention it here because I think it shows the value of alternative dispute resolution more broadly, and taking the skill sets we learn as neutrals, be it an arbitrator or a mediator or a neutral evaluator, and applying it when you're not a neutral. So, you know, Chris, you and I have chuckled about the fact that sometimes I'm now called a patent fixer. And really what it is that I work with operating clients, other patent clients, and on their behalf, I will set about resolving their disputes outside of litigation. I sometimes tease my former litigation colleagues and say, my job is to put you out of business. But the good news is if I don't succeed, I'll refer it to you. So it works out. But there's a couple different examples of that I wanted to share with you today. The first is that I've represented for some time now a large technology company that, like most large technology companies, constantly has entities that are seeking to monetize their patents, knocking on their door, saying, here's my portfolio, here's the very large check I would like you to write to me. Sometimes those are patent aggregators. Sometimes those are competitors who have decided to monetize a portion of their patent portfolio. What I've found is, there's a sort of dance that goes on, and many of you are familiar with that, where there's these meetings and claim charts, and it goes on, and with the goal of a check changing hands at the end. If you apply many of the principles that I outlined in the mediation section to this process, you can set up a far more productive and informed and likely to lead to a solution process than you could otherwise. So when I'm called in to respond to a particular entity that's asserting a portfolio of patents, the first thing I do is say, well, if we meet, who should be there? When should we meet? What information should we exchange ahead of time? Almost all of the same questions. But if you set those meetings up as carefully and skillfully as you set up a regular mediation, you can almost self-mediate on behalf of your client. If you, in the negotiation, build those off-ramps I talked about, think about who it is across the table. Think about what they need to get out of it. You can apply a lot of the same principles to resolve something before a complaint is ever filed, and hopefully a complaint never will be filed. And so that's just an interesting application of these principles. I've also done it for some biotech research institutions who, it's not the monetization things, but it's revenue sharing. You know, there's a lot of revenue in pharma, and how you share it between all the people contributing to a given drug coming on the market is a lot of money at stake, and a lot of disputes around that. Once again, you can set up those discussions using the same principles that were just outlined to achieve resolution. So that's something that I think is an interesting way to take the skills and the goals and the success, frankly, of alternative dispute resolution practice and apply it to situations where there's not a formal ADR process and without even perhaps a neutral. So I wanted to share that because, you know, a lot of money goes into litigation and arbitration. It can be a zero-sum game. It's absolutely necessary sometimes when parties won't behave in good faith, or perhaps they just disagree about a very big issue and they just need an informed third party to decide it for them. But in my experience, those situations are few. There are far more where the case could and should be settled by informed counsel and parties. And doing that as skillfully as possible, I think, is a real service to both our bar and our clients. Those are my thoughts on alternatives. So I'm happy to take any other questions that, or suggestions or helpful hints that any of you have to share.
While you all think of questions and type them up, Vicki, following up on what you just said, maybe in 2 or 3 bullet points, what do you think, which of the principles, the mediation principles or fixes that you've talked about or techniques are applicable not just to patent cases, but more broadly for mediation of the other kinds of disputes that we all get involved with?
So what are sort of the principles for that? Well, you know, I think that remembering as a neutral or a counsel that you may not have the best solutions yourself. It's not about you because you're not living the dispute the way the litigants are. And if you bear in mind the principle that one of your charters is to really elicit from the party what they care about most, get them thinking creatively, not reflexively, then you can, and if you listen hard to what they're really saying about what their goals are for their company, what their goals are for resolving that dispute, and then you do the same kind of listening from the opposing party or the other party if you're the neutral, you might start to see some overlap. And if you use skillful listening, skillful questioning to elicit that, to get behind stuff. I mean, you know, we've got smart, savvy, sophisticated parties in this business. So yes, I am keenly aware that also people will posture for me, the mediator. Like they will want to portray a certain confidence. But if you are with that party throughout the day or on phone call after phone call, they will build up trust. So that's the other principle, building trust, that they will trust you not to go, you know, just immediately and sort of let the cat out of the bag with the other side. Obviously, we have ethical and confidentiality obligations, but you can honor those in different ways. If they trust you that you will hold their confidence, that you are earnestly trying to help them, and that you get it, they will often open up and you can find these overlaps. So I think being creative, you know, and listening. So, you know, I'll be in a dispute, for example, let's go to the representing the operating company in a conversation with a monetization entity. one time, the client on a break says, you know, they're in the business of monetizing patents, acquiring them, and monetizing them. We've got some patents that we could sell them. You know, we don't really need this portfolio. How about that? That would never have come from me. I didn't have that solution, but by asking the right questions, listening to them, creating an environment where they can think creatively, that came up and was part of the solution. So those are the principles that I would suggest.
So, Vicki, do you have to be a patent lawyer to handle a patent mediation? Is it essential, helpful? Sometimes doesn't matter at all. I mean, how do you evaluate that?
A great question, and I would say that the parties and their counsel usually express a preference for a patent attorney. And my belief is that it's easier for a patent attorney or litigator to be the neutral because of the lexicon, because people can speak in shorthand, because they feel like you can keep up and they will have confidence in you more quickly. So I think it's an advantage. And because you're used to dealing with battles of experts and you're used to, you can speak in the current parlance and you know the recent case law. But is it essential? No. And there are some people who can very effectively mediate patent cases who are not patent attorneys, but they need to really make sure they study up enough to not slow things down too much. But sometimes slowing things down helps. Sometimes those folks will ask questions about things we would take for granted. Sometimes they'll think of solutions that are outside the norm. So I think there tends to be a preference for patent attorneys, and I think there tends to be an advantage that you have if you go in just knowing the drill and knowing the dance steps. That certainly helped me a lot to be able to think back to when I was prepping that witness or when I was writing that brief or arguing at the Federal Circuit or whatever it was, what all went into that. It's helpful for me to understand what they're going through, but I don't think it's essential, and a highly skilled mediator without a patent background could succeed.
Great. Well, we have just exactly come to the end of the hour. The timing is perfect. Vicki, I want to thank you on behalf of all of us for taking this time and doing all the preparatory work you did in putting together these slides. I think all of us have found this really valuable. There have been, in lieu of questions, a number of, well, there's one more question. I'm not sure if we have time. A number of compliments coming your way. I would encourage any of you who have participated in the call to get back to any of us, including Vicki or Bill Seward or me or anybody at the SVAMC and let us know what you thought and what you would suggest by way of future topics. We're going to try to do these quarterly. I'm sure Vicki would love your feedback as well. So again, Vicki, thank you very much. If there are questions coming up that are past our deadline here, I'm sure Vicki will take them offline. Thank you.
Yeah,
and
I put my email address on the screen. If anyone wants to reach out to me with questions that way, I'm happy to take them.
Terrific. And you can check for her radio show later. I'm sure she's going to have a weekly session talking to Vicki or something. Or if she doesn't, she should. Thanks again, Vicki.
Well, YouTube, since we did the video today, we'll try that one. Anyway, no, thank you for the opportunity.
Okay. Bye-bye, and that'll be the end of this one for today. Talk to you all later. Bye-bye.